I could get people's attention, we want to start our next panel, and we have a number of familiar faces here, two of whom I've already introduced, but we'll do so again. Ray Gifford, who's been with us since the beginning, has been chair of the Colorado Public Utilities Commission, has been president of the Progress and Freedom think tank, and he also is a senior adjunct fellow for Silicon Flatirons, chairs our advisory board, and a partner at Wilkinson, Barker, and Knauer. Next to him is the man who needs no introduction in this room, Dale Hatfield. For those people who think clearing broadcast spectrum for wireless commercial uses is a new thing, he'll show you his work from the late 1970s dealing with the same topic. And he really has been around this world for long enough to know almost everything and everyone, and he's probably taught almost everyone everything. So we all owe Dale a real debt of gratitude. Matt Larsen, who's a repeat player here. Matt is really an unbelievable innovator, entrepreneur, and leader in the wireless ISP world, where a lot of interesting innovation and use of spectrum is happening, and we're thrilled to have him back. Travis LeBlanc is here for the first time. We're thrilled to have him on board. He is the head of the Enforcement Bureau at the FCC, which, given our topic to discussion today, makes him uniquely well suited to join us here. We're thrilled to have him as part of our community. And Doug Sicker, who with a heavy heart, I have to say, is a senior fellow now from his post in Carnegie Mellon, where he is, I'll say, temporarily camped out because still have to get him back here to Colorado. Doug.
And he wears suits.
I know, I was about to say, look what happens when he goes to Pittsburgh.
This is my DC look.
There you go. So we have a important agenda here, and I want to get into it by first setting the stage, because it's important to get the basic foundation. The phrases enforcement and adjudication are different, and what I would say is adjudication is having a forum that can make judgments about disputes, and that forum can actually allow a plaintiff and defendant to come before the forum and make their case, and the forum makes a decision. Enforcement can be either private or public enforcement. So sometimes the plaintiff is a private actor who's enforcing their rights, but sometimes the public body does the enforcement. So, for example, in copyright, we have the Department of Justice, which does copyright enforcement. Sometimes it's a criminal matter. We also have individual rights holders doing enforcement, and there are different possible forums that can adjudicate these disputes. Now, in spectrum, it's worth noting historically, there weren't many forums for adjudication, and there wasn't much enforcement either. The poster child that is, in a sense, the case study that all of us in the spectrum world need to feel embarrassed about is the XM Sirius matter, where for years, in what Dale will tell us was an open and notorious fact, they continued to violate the terms of their license, creating interference in adjacent bands such that the adjacent bands were not usable, and the FCC never decided or acted in enforcement capacity. When did they finally act? As a condition to a merger. And it was a self-styled enforcement action that happened to come down the same day as the merger was approved, and Commissioner Deborah Tate, in a statement that was quite honest about this, said, we should all be embarrassed. So, and that was 2006, I believe, right? XM Sirius merger, 2007 maybe. So we have to recognize the legacy that was, and what would it mean to change that game, to create an institution that can engage in, real enforcement and real adjudication. And as Pierre said, our paper talks about the FCC as a forum that could do both those things. It's also worth noting what the FCC has done a lot more of, and it's important, is not traditional enforcement or adjudication, but call it cop on the beat, which is they might send someone a letter and say, hey, by the way, it looks like what you're doing is a problem. And a lot of times that would remedy the situation. But unfortunately, some actors, see XM Sirius, kind of knew that a citation that would never get backed up might not be all that moving. So actually, the less sophisticated the actor was, the more likely they were to comply with the law as dictated by the FCC. So Dale, I want to start with you and say, did I give an okay background about where things were in terms of adjudication and enforcement? Is that a fair summary?
You're asking me to comment on the law school dean?
Well, you were there.
No, I think that's a pretty fair description of what happened then, and in general how enforcement has worked up to this point.
And so let me ask the question this way, just to start with the generous. Are there any advantages of a much more informal system? And what are the disadvantages of it as we think about the FCC maybe moving towards a more formal model? Did anything, because you've told me, you said some things actually has worked in that model. The informality of sending letters to people, for example, could lead a lot of people to change their conduct.
Yeah. Well, and even before that step, a lot of what the commission does is, of course, as I think we heard on the previous panel, is encourage people to solve the interference problems among themselves. And one of the things I would hate to see is if we move to a more legalistic, and I use that kindly, process, that we don't lose in that process the stuff that works well informally. And I would further say a lot of that is hidden, that a lot of things where people negotiate and figure it out never gets in front of the commission, so there's no record of it. You won't find something that you can go in the law book and find that, hey, this was settled. It was done very much at the local level by professionals at the local level. So the message simply is be careful that we don't inadvertently convert things that are working pretty smoothly on an informal basis among parties.
So, Ray, among other things, you are a student and an astute observer of institutional design and institutions around enforcement and other matters. How do you see where the FCC's history has been and what room there is for improvement?
Well, I mean, I think what I want to talk about is Ronald Coase, right, who started with his article in 1959 on the Federal Communications Commission, the notion that property rights in spectrum and spectrum auctions were the way to allocate spectrum. And one of the things that arises out of the Coase theorem, and this gets to a little bit like about Dale's point, which is if transaction costs, which in this case, if search costs are kept low by the FCC to know who is next to me and who may be doing good or bad things, you do have a strong means to have those informal issues to be worked out. The other thing that Coase emphasizes, or that kind of falls out of Coase, is the property right has to be adequately well defined and known for transactions to take place or for adjudication of that property right to be clear. So I think in the abstract, what your goal is to lower search costs and transaction costs so people can transact informally. And second, make the property right firm and clear enough such that, and that may require adjudication and enforcement. And if the property right is clear enough, you will have both market and informal ways to work out problems.
And this is an important point, by the way, that adjudication plays. We take this for granted in our system, but as the law school dean, I'll underscore it. By getting case law or other determinations out there of the nature of the right, that provides people with notice and awareness of what rights they have. Whereas if you withhold adjudication and no one knows exactly the extent of their rights versus someone else, that becomes often an impediment to cozy and bargaining. Travis, let you jump in, because you've come in from the outside to this new world with a mandate to change the culture. Do you want to say a few words about kind of what you are doing, have been doing, and how you're seeing the evolution of the Enforcement Bureau?
Sure. I'll pick up where Ray left off with the Coase theorem, and as well as your comment about adjudication and its value towards certainty. Adjudication and the common law system certainly does have its value, but the real heft of the Coase theorem is that there are certain predefined rights. The folks, when they have that dispute, they know how it's going to get resolved. And for me, when I think about enforcement, and I'm going to talk a little bit about a sort of philosophy on enforcement, but also about the Enforcement Bureau, because I think it's important for this group to understand what the Enforcement Bureau does, the tools that we have available to understand our role and where we can ensure that spectrum rights are being enforced. There's no question that a successful regulatory regime includes effective enforcement. And when I was, when Chairman Wheeler announced my appointment as the chief, he said that the credibility of the Commission's rules ultimately depends on its enforcement activities. And I think that that's definitely true, not just for its rules in general, but particularly with respect to spectrum enforcement. The way that the dean characterized enforcement versus adjudication, I think is fair, and the history of the FCC is fair. However, I would tell you that from my perspective, enforcement is not just reactive, it's also proactive. My job as an enforcer is not to ensure just that once someone has a complaint, once someone is experiencing interference, once someone has been, once someone has broken the law, that we're then responsive. In the ideal world, we're preventing things as a commission. In the ideal world, we're stopping problems from happening so that we're proactive. And there's a couple ways we can do that. From the Enforcement Bureau, I can do it by looking for issues before they become a problem and spotting them. But moreover, the rulemaking bureaus, the ones that are setting the rules, that are setting the requirements for licenses, they are setting what are the way, the certain requirements to help the industry, to help the public avoid engaging in interference. And so I like to start there and sort of say the enforcement process begins with rulemaking, right there, because the rules themselves are going to stop 85% of the problems in and of themselves, because they give certainty. And they're going to allow the industry, when there are disputes, to resolve them privately before we ever have to get a call in the Enforcement Bureau about a problem. So at that point, we come in once someone has, we come in when we begin to advise the rulemaking bureaus. That's something that's sort of new under my tenure. We've had a lot more robust advising of the rulemaking bureaus before they write the rules. Why? Number one, so that they can know how to write enforceable rules. Rules that we can later use to our effect. But number two, we're the boots on the ground. I have an enforcement bureau that has 23 field offices around the country. We have 3 district offices and 3 regional offices, all of whom are out there doing, spectrum-related issues. Well, we see what happens. We hear the complaints. We get them. We can take those back to the rulemaking bureaus and help them solve those holes to fill in those loops. And that's very important in the process itself. But once we do get involved from the Enforcement Bureau, we do have a complaint that comes in the door, our first goal is to always encourage private adjudication and resolution, I should say, rather than adjudication, private resolution of the complaint. Because sometimes it actually works, and it's an efficient use of government resources in addition to an efficient use of individual resources. Someone was on the prior panel made very clear that when you call the FCC, it can often take a long time to get towards a resolution. If you can reach a private resolution first, that's great. However, there are times when that does not happen. Well, you have a couple of options. We can be a cop on the beat. We can send someone. We can identify where the interference is coming from. If we can identify it, we can then show up. We can knock on the door. Presumably, we could determine who it is actually causing the interference. That's not always easy to determine, but presumably we can determine it, and we can play cop on the beat and resolve the issue. That's not the only way it can get resolved. In the Enforcement Bureau, we have a Market Disputes and Resolutions division, which allows businesses to or licensees to formally file a complaint with us, and we then adjudicate it inside the Enforcement Bureau. We can do that through an arbitration type proceeding that takes place, or we can do it through mediation. But we have a division to do that if there is a formal complaint. No surprise that takes some time to get through. It's essentially litigation with the filing of a complaint, an answer, then discovery, and then ultimately a resolution that's there. about 1/3 of the Enforcement Bureau personnel works on spectrum issues. They come through the field office I spoke about. We also have an equipment development group, which is located in Georgia, and they primarily support the work of the field in developing direction-finding tools agents can use to monitor, detect, and locate interfering devices. That's important too, because we need to make sure that we have the technology to identify the interference issues when they're ongoing. We also have within the Enforcement Bureau a spectrum enforcement division at headquarters, which typically enforces wireless and public safety substantive rules. This division focuses on a lot of emerging technologies and spectrum uses. It's doing some work on, or has done some work on, blocking technologies and on interference that jeopardizes public safety. For example, around 911 issues. So for me, I think it's important that we be proactive, not just reactive. I think it's important that we assist the rulemaking bureaus, and I think it's important that we not only use our functions as a cop on the beat, but also our adjudicatory functions. We have a lot of tools. Depending on the problem that's presented to us, that's how we choose the tool that's available to us. So on the Sirius and XM scenario that you gave up, yes, it wasn't actually a merger condition. It was done in connection with a merger. But here's the thing. That is a tool that's available to us. It's a way that allows us to resolve something. So just like we have, formal complaints, we have cop on the beat, we have mergers that come before us, we have rulemakings that are there, we also have the ability to look at other options, such as an ALJ would be another option that's there. I think in looking at these options, what we have to ask ourselves is, each has advantages and each has disadvantages. And the way I generally characterize those advantages and disadvantages are along 5 metrics that you can look at. Number 1, the time to resolution. Depending on how quickly you want to resolve it, I may choose a different tool that's there. A second factor that I look at, resource intensity. Some of them take a lot more resources than others. Sure, sometimes we use a cop on the beat. Why? Because we can knock on a door and we can resolve the issue. That's so much more efficient than submitting it to an ALJ in Washington, D.C. and expecting everyone to get on a plane and go there and adjudicate the matter. The third thing we look at is the comprehensiveness of the legal authority. How certain is that legal authority that we're dealing with? Where it's very certain, I'm much more likely to use the cop on the beat. Where I feel it's really complicated, it's not quite there, maybe we bring in an ALJ. Maybe we look at the rulemaking bureaus. The fourth factor that I think about are the parties involved, including, and I really want to focus on their sophistication and the resources, and in particular, is it a government party, right? That's not going to look so well in adjudication before the FCC if we've got the Department of the Navy that's being accused of interference, and we've got, what did we talk about earlier, some homeowner who's got a garage door that's having a problem. We all know how that's going to end up. So it's not a fair adjudication to do that. And then the fifth factor I consider in thinking about the tools there is what other activities are ongoing in the commission that maybe, and who else in the commission is engaged in something relative to the subject matter of the enforcement action. If I know that the Wireless Bureau is doing a rulemaking on this right now, I'm probably not going to submit it to an ALJ. Because the Wireless Bureau may be changing the rules entirely if the commission adopts what they're going to do. And suddenly we have this ALJ matter that'll go on for 2 years trying to look to enforce rules that are no longer in effect. It's not a good use of the ALJ's resources, it's not a good use of our resources, and it's not a good use of theirs. So I think it's a lot more complicated than maybe it's been, than enforcement is initially thought of.
So Doug, one thing Travis has touched on is, I'll call it observation and measurement. And one of the challenges in spectrum is what systems out there, so from the Enforcement Bureau's trucks to others, are helping us learn what's actually happening in the field to inform these judgments. As the former CTO of the FCC and NTIA, and as a scholar, I know you've thought a lot about this. What would you add to that part of the equation?
So I guess I would take one step back first and say it's interesting to talk about the Enforcement Bureau as the cop on the beat, because I don't think it is. And with all due respect, the Enforcement Bureau has an incredibly difficult job, but they're much more responsive to complaint as opposed to out there monitoring all of the spectrum. And the reason that is because it's a job that you can't do. We couldn't get enough people. This is not something we're going to solve with people. This is something we're going to solve, as Travis said, either with rules on the front end, which are going to narrow the probability of those types of events, or with a complaint process and a measurement process. The other challenge, and this gets to your question, Phil, it's still very hard to identify when interference is happening. And we even the rules as they're written now as to what constitutes interference and under what conditions, maybe it's because we're still based on a transmitter model of a power mask at a transmitter as opposed to what Pierre and others have been championing in terms of interference rejection criteria of a receiver. These sorts of differences, I think, will be embraced, and I'm very pleased to see in the last year just what's happened inside the Enforcement Bureau to start looking at these new ways. But again, back to your question, Phil, there's a lot of modeling that's being done now in the radio space, both static models, that you would run on a machine, on a computer, to understand how we should anticipate radio propagation to occur. And why that can be done now is because of the sophistication of the tools that can model the terrain, that can consider just how the radio propagation actually occurs. And with that, now what we're able to do is get a much better sense of where and how radiation proceeds and what kind of interference might happen as a result. So as we start moving toward new technology, and I'm not going to say that technology is going to answer everything, that's ludicrous, but we can start relying on the use of technology and feedback mechanisms as well as rules that are based on modern models. One of the big complaints I had, and one of the things I beat the Commission and NTIA up about, we were using propagation models that were ancient, before Bob's time. So they were
That old?
not as old as you, Deb. So we've really started to embrace new technology, and I'm pleased to see this. And this is going to be really important going forward because, again, we have to understand that we're now packing more and more services. More and more opportunities for interference are going to arise. If we don't understand it, and if we don't create both rules and then processes after the fact, we'll just be plagued with interference, and it will really collapse on itself.
So one reason why it's great to have Matt in the panel is we get a reality check. Matt is on the ground operating a company that uses both unlicensed and licensed spectrum. What's your experience on the ground in terms of, when you have interference that you detect, how do you go about enforcing your rights, seeking some kind of adjudication or at least remediation? What's the reality look like to you, Matt?
Yeah, one of the strongest points about unlicensed spectrum is in a lot of ways it's a form of mutually assured destruction. If somebody's interfering with me pretty bad, I obviously can look at my choices. I've got the ability to change channels through one of the other chunks of unlicensed spectrum. I can go to the user and see if whoever's interfering with me and see if they want to change their stuff around so that they don't interfere. And if they don't want to interfere with me, I can turn around and interfere back with them with pretty much no...
Self-help, if you will.
Exactly. Unfortunately, some of that starts to break down a little bit. We're starting to see some
of it's unlawful too.
Yeah.
It's a serious point. I will say, in Matt's defense, in unlicensed, I think there's yet to be much enforcement limiting that in unlicensed. Although in theory, if you were using power above the limits, that would be unlawful.
Exactly. I mean, there are legal ways to interfere.
We just did
a
a settlement with Marriott Hotels, which was involved Marriott sending deauthentication packets to the MiFi or hotspots of guests in its conference facilities to essentially shut down those hotspots. That's an example, of sort of hijacking the unlicensed Wi-Fi, and in doing that, they were doing it, of course, so that you would pay for their internet access, which they charged in their conference facilities up to $1,000 per device for internet when you show up with your own MiFi or your own hotspot that you want to set up. That's a perfect example, of a recent action that we did just last month in the unlicensed Wi-Fi, and it's an example where you have one entity attacking another. It's effectively a denial of service attack that they were engaging in on those hotspots.
And just to underscore the enforcement versus adjudication, that was a good enforcement action with a consent decree. It was not an adjudicated decision. So after this was announced, I sort of gave a shout out and tweeted this as a great step in spectrum policy. And someone responded and said, well, we're not sure what actually happened. And I was like, well, in the press release the FCC said, they were pretty specific about what happened. But because it was a consent decree and enforcement agreement, I guess there was room for someone to suggest there was something above board happening. But my read was just like Travis said. This was a pretty clear incident of someone abusing their spectrum, even if it was unlicensed spectrum, willfully jamming devices. So
yeah, that was the view of the Enforcement Bureau. I would also encourage, there was a press release for it, but there's also a consent decree. And the consent decree has a fairly robust background section in it that lays out what the Enforcement Bureau believed that Marriott did, and it also lays out Marriott's bases for it. Marriott said, they signed a consent decree that specifically says there was no security threat to their network at any time. The only reasonable basis that, at least I personally have seen for it is that they were using it to charge folks in their conference facilities up to $1,000 per device to use their internet.
So Matt, what would you do if you had a...
Let me ask something. This is important. In terms of policing, getting back to that, how was this identified? This was identified because somebody realized, some consumer figured out that they were being blocked, right? This gets back to why you need the tools and to have an educated consumer to actually help, right? Because this would not be something you would be able to identify, right?
Well, the thing about would we be able to identify? Sure, if we spot it as an issue on our own, we could send people out and we could try to identify. But that's almost like a needle in a haystack.
Exactly.
Right? I have limited resources. So, I wait for consumers to call in and complain, but that's not the only way cases come into us. A case I could read about it in the press. Some journalist could write about it. We could find out about it from there. A member of Congress could write us about the issue. We could learn about it from them. Another government agency could refer the issue to us. We learn about it from them. I can hear another office or bureau in the FCC, maybe in a meeting, or they hear about it from one of the regulatees, and they then send it over to us. So there are a number of different ways that we can find out about a potential problem. In this one, it was a consumer, but we also did have a member of Congress that wrote us about it.
So Matt, what would you do if you are being subject to, let's say it's illegal, it's either high power and unlicensed, or it's jamming, so it's kind of malicious. As a practical matter, how do you handle those?
Most of the time what I do is try and figure out a way around it. There's a fair amount of unlicensed spectrum out there to use to try and deal with it. In effect, we see a lot of this already. A lot of the urban areas are seeing cable mount hotspots coming online, to where a lot of the 5 gigahertz and 2.4 gigahertz spectrum that our industry is very dependent on is the noise floor has been increased to unreal levels. And it's pretty hard to prove the evidence that there's any actual commerce or activity taking place on that spectrum at this point. We've really seen it in 900 megahertz, where utility companies have started using 900 megahertz to read meters, and it's also heavily prevalent in precision farming. And what it's done is essentially rendered 900 megahertz unusable for broadband delivery in those places. And what's really a shame there is the death of being able to use unlicensed is actually a reflection of the economic success. They're using it because the equipment is inexpensive and because there's fewer hurdles to deploy.
So this is the Yogi Berra, it's too busy, no one goes there anymore.
Bingo.
I didn't say half the things I said. Wasn't that Yogi Berra also? Yeah. So, this creates a problem. This is, by the way, one thing that enforcement can help do, which is, if someone does have priority of rights, helping to ensure that they have it, because this noise floor issue, and let me go to Dale now, this is not only an issue in unlicensed. From what I've learned from Dale, the noise floor is also impacting licensed bands as well, and creating a harder causation question. And so one of the institutional challenges, I want to segue to this, is how can you, when you have an adjudication, a dispute, how do you get the evidence and the decision when you have complexities that really require untangling different factors, including this noise floor, which is becoming a problem in other bands as well?
Yeah, especially the bands maybe below 1,000 megahertz or something like that. We have technical means of being able to sort out now and really look at what's happening in that noise floor, but it's made up of little bits of interference from lots and lots of different people and lots and different mechanisms, and it's just difficult. It's just difficult to track them down. And some of the solutions are, if it's an out-of-band emission, it's an accumulation of out-of-band emissions, then you could have a rulemaking proceeding, and over time maybe try to do it. But even COAST doesn't help you in that case much, because you've got all these devices out there that are owned by lots of different people and so forth. So there's nobody to bargain. There's nobody to bargain with. And
I mean,
you have to resort then to the rule. Come back to some sort of a rule.
Yeah, I mean, it's not the classic trespass case where I come over to your band and say, "Here I am, Dale. Stop me." It's all of us leak a little bit into your band, and collectively we do you in.
And there's still some uncertainty here, but when you look at some of the plots that people make, you can see urbanization. You can see the noise level in urban areas, and you just drop out in the country, and it's very, very apparent. And it's the sort of thing that concerns me. You can overcome it, of course, by increasing your power, but then increasing your power then causes a whole other set of issues.
So let me talk about different institutions that can help make these adjudications. And different agencies in the federal government and the state governments have ALJs, contested proceedings, and I want to ask the question about how that works. Conceivably, either two private parties before an ALJ, then goes up before the commission upon appeal from the ALJ, or one public authority. So say the Federal Trade Commission brings a lawsuit, they'll bring it forward an ALJ against a party, and then you'll have a separation between staff and the commission, so when the ALJ decides, it gets appealed to the full commission. When you've looked at these models, Ray, what do you see as the strengths or weaknesses of having an expert agency with the ability to both host private disputes before an ALJ or some type of administrative judge, and also the model where the government itself is both prosecutor and judge in the same agency?
Well, I think what you worry about, and particularly given the history of the FCC, is in that latter where the government gets to both prosecute and decide, is that you have a systematic bias, as Travis talked about, right? Is you don't want to be litigating against the Navy because, they've got aircraft carriers and stuff. And maybe I'm jumping forward to next spring's conference on water law, but if you look at how the Western states have handled their water court situation, is they've set up special courts with special engineering expertise with them, and private parties can go into the water courts and try their cases. There is also a state water engineer who has independent authority to bring cases in front of those same water courts. And I think as a general matter, and I can't say I know a lot about water law, but enough to be dangerous and at least prepare to moderate panels on water law at Silicon Flatiron, it's a model that, for the most part, the players in that world think has enough integrity and reliability that they use it. And the other thing about water courts out west is most of the players in those courts are government agencies, right? City and County of Denver owns the most water of anybody in the state. So when I think about what sort of institutional models we have out there to handle this, I jump immediately to the water court model. But part of it gets to the agency's culture and its perception in the relevant community. And that's where I think the FCC has a ways to go.
So, Doug, let me jump to you. Having both been at the FCC and the NTIA, and as Ray and Travis have both now introduced to the conversation, one of the big X factors is that a major licensee of spectrum is the federal government. We'll stick with the Navy as the example. Could the FCC adjudicate spectrum disputes where the Navy is a party? Would we need to create some other type of court, like a water court analogy or court of federal claims, because if the federal government is going to either license, in whole, they vacate spectrum that's next door to it, or share it, there will be a need at some point for enforcement adjudication. Who should do that, Doug?
Yeah, that's a really good question, right? Because right now, how we're set up is we're reliant on the NTIA as kind of the middle ground there, but there's a lot of influence of DoD on NTIA's actions and positions, and so the relationship between FCC and NTIA in terms of working through some of those issues and even just getting, as Travis said, the rules set on the front end, which are incredibly important, is very compromised by how that model works now. So what we end up getting are rather constrained solutions to the problem, which then don't actually free up as much spectrum as you would want. So I think that whole area actually could really use some good thinking, and I don't know the solution to be. I'm not a lawyer. I don't pretend to be one. But I've seen so many challenges as we've tried to reallocate or even share federal spectrum by commercial entities that it's somewhat shocking. And the classic recent one was a 1755 to 1850 megahertz spectrum, which everybody knew wasn't being used. It just simply wasn't being used. But it was a very controversial effort to move that spectrum into commercial hands, and it's taken a few years, not 10 years and $18 billion as NTIA had originally reported. They were able to get that through, I think, in 3 years, right, or 2 years, or whatever it has been. But this is an example. That's a great example where it's not clear that any of these entities there have the authority. I don't know where that authority would sit.
So just to underscore this dilemma, and then Dale's done a lot of thinking on this, so I'll let him mention it. What the DoD will say is, I can't vacate this spectrum because it might be next to other spectrum I'm using, and in effect, I'm using this vacant spectrum as a big guard band. If I could trust someone to enforce my rights as an adjacent user, maybe I would be okay, but right now I can't see who that is. Dale, do you want to elaborate on that at all?
No, I think you said it. Yeah, I mean, seriously here, who's next to you is a big thing, and of course that gets into the whole light squared issue. Obviously, is when you get spectrum assigned by the government to you, how far out do your rights, and this goes back to the harm's claim threshold, which I want to reemphasize here underlying this. That to me is the key to getting those rights, right, is the harm's claim threshold. So Pierre's been, of course, pushing for that. So in fact, I've said myself that I would sort of retreat from this whole area if we don't get some sort of pretty sharp definition of what harm is. Then I think this is all kind of useless. We'll be fighting forever without a clear rights definition. So I evaded your question.
You evaded. I'll go to Travis. Travis, so we have this challenge. We got to define what the right is, and we tell the party, okay, here's your right, and here's the way in which we will enforce the right. What do we do when one of the parties is a part of the federal government? This is a yet to be solved. I don't know that you have a solution to add either, but given that we're really hard-pressed to find access to spectrum, the importance of solving this is going to only increase.
Yeah, with spectrum sharing, it's going to become even a bigger issue that we're going to have to deal with. When I begin to think about the problems that come with spectrum sharing, the first thing I start to think about is, how are we going to define who is actually causing the interference? That's just the very first question. Before we realize that it's the government that's the problem or it's the consumer, to use consumer industry, we got to figure out how to identify who's at fault there. But let's suppose that there are rules there, and now we know in this instance that it's the government. What we in the Enforcement Bureau are not able to adjudicate claims against the government. That's not what it's not our authority. But what we can do, and what we regularly do is work with our other government partners to see if we can reach a resolution. I would not suggest that you want government agencies litigating against each other in court. I would not suggest that you want to have one government agency appearing before another government agency to help resolve an issue. I think that we're all one government, And it's important that we collaborate and work with NTIA. It's important that we're able to work with DOD. And generally, we are able to resolve the overwhelming majority of issues at a government-to-government level. The big thing is that we know the folks who are working on it, we can pick up the phone, and that we can all work in a collaborative spirit to help resolve the problem. And I think that going forward, we're gonna have to rely upon that more. For me, when you have situations like this where there's an asymmetry of resources between the disputants, it's critical to have as many fora as possible where those can be resolved, and it's critical to have as many potential litigants as possible so that you don't leave the little guy all by him or herself to face the big bad government or big bad industry. And that by giving them lots of different tools, whether it's, you know, a hearing before an ALJ, whether it's, you know, an alternative resolution before, you know, the Enforcement Bureau in our Market Disputes and Resolution Division, whether it's having us send an agent out to try and resolve the issue, or it's some kind of conference or consortium where we bring folks together. There's lots of ways we can do it, and I think we need to do as many as possible.
So that gets me to my, yeah, Doug, go ahead.
But I do want to add, I don't want to sound too critical of the process that was launched and successfully through NTIA and FCC and a lot of other government agencies and industry. They did come together on this particular ban that I mentioned, and there was resolution. So as Travis said, that's the best way where you bang out the deal. It's a lot of work.
So I want to get to this, my last question, which is there are alternative models that are emerging. One is crowdsourced enforcement, which is something that in one of the reports Dale worked on, talked about, which is get lots of people to share the information they're getting on their devices in a way that facilitates a resolution of, oh, this person is causing the harm or behaving how they shouldn't. And that could be implemented in lots of ways, including like even adding a bounty for someone who is the catcher of the misdeed, or other models where you might allow for sort of a fast track, you know, arbitration type, where, you know, someone gets to put forward, hey, I've caught somebody, and that would generate a result. What sorts of ideas might you have? And Matt, let me start with you, because we talked about the little guy. The truth is you can't afford to spend a lot of your time, you know, engaging in the nitty-gritty of a legal proceeding. You need this to be quick and dirty. You need it to be transparent. So are there models that you've heard about, including one I just mentioned, is crowdsourcing, that you think, yeah, that might work? Or how do we do, you know, call it more pragmatic solutions along these lines?
One of the things that's really difficult for us, as you mentioned, is, you know, taking on big entrenched organizations. You know, I could point out the issue with TDWR, Terminal Doppler Weather Radar, and the FAA's insistence to use 30, 40-year-old radar sets that are incapable of handling interference. And what really needs to happen is somebody needs to take a look at the economic balance of opening up that spectrum for unlicensed use and what kind of value that would open up versus what the cost is to retrofit these radar systems with actual modern systems that would be more resilient to interference and actually safer in the long run. But there's a very established, you know, entrenchment at the FAA because you don't want planes crashing and that sort of stuff.
Well, part of what they would say, I gave you the Army's version, here's the FAA's version, is, oh, sure, we're operating on more spectrum than we might really need, but we need to keep it protected because it'll better ensure that we don't have planes crash, which has a way of silencing conversation. So you could get both more efficient systems and some effective system of enforcement that could be a win-win, but it is a paradigm change.
Yeah. And, you know, one of the things I know it's come up a lot here, the idea of spectrum sharing and databases, and, you know, there are definitely some good benefits and some good theory behind that. But I have some reluctance to certain elements of it. One of them is this issue of dependency on an outside entity. You know, I like the idea of being able to buy a piece of equipment and I can put it up and it's going to work in the way that I intend it. I don't like the idea of being dependent on an outside entity that's going to control what my operational parameters on that are. And I recognize the need for some of that. But just to throw an example out, if, you know, Google's running the database and then Google decides to come in and compete with me, I'm not feeling so good about them running the sharing database on it. So there's some...
And just to kind of add one dimension, sometimes these systems would allow for messages to automatically shut you down out of concern. And so there's a real need for trust and transparency.
Well, and it opens up for gaming of the system as well. Because, you know, we've already seen a lot of that, especially in rural areas where there's a lot of spectrum warehousing, where companies have spectrum and they don't do it. They don't do anything with it. They essentially have the spectrum just to keep competitors out of the market. So we can dice this up into smaller and smaller chunks, but it just takes the gaming to a different level. It takes from layer 3 to layer 2. Yeah. And I have some concerns about that. Also, the other thing that happens is, you know, I think there's some great potential has been squandered in TV white spaces because we've gotten too cute with how we want to handle it. And what's happened is we don't have any devices. You know, we're almost 10 years in on TV white space. I don't have anything that I can go out and economically deploy to a customer. We've got giant chunks of the country that are without access to broadband because we've been too cute with our spectrum policy and have not been able to come up with anything that actually works out in the field. So when we talk about what goes on in policy and rules, there's also a consideration of translating those rules through the devices that are going to be available to deliver that service. And it starts to add complexity, it starts to add cost, and it starts to raise hurdles. And I hate to see a situation where we raise hurdles so high that only, you know, the multi-million-dollar and billion-dollar companies are the ones that can go out and innovate. We need to have some room for grassroots innovation that can, you know, help redefine and be disruptive towards what's going on in the marketplace.
Doug?
So I think it's important also to recognize from a technology perspective, I think also as from a society perspective, we are at an inflection point in terms of how radios are operating and what they can do and what our expectation is of these devices. DoD is a great example now. In the last 5 years, they've moved from that kind of classic, this is how my device works. It's, you know, it's on a acquisition. I'm not going to replace this for 10 years. It's going to be really inefficient. To now they're looking at each device and saying, hey, it's actually, if it's agile, it could be more reliable. It can operate and get around things. If it has more of an adaptive model, if it starts borrowing from some of the simple things that we think about in the internet design in terms of redundancy and you know, relying on retransmission or whatever it might be, it's going to make that thing more protected from interference, which ultimately is a very important thing for DoD. So they're looking at this, and others are looking at this. I mean, devices are getting smarter in terms of little things. Even LTE technology is getting smarter. Certainly, Wi-Fi technology has done a lot of this over the years. So there's things that are happening, and I think that combined with crowdsourcing and other things are going to really change. You know, 10 years from now, I think this is going to be a different discussion. And it could even be like on the crowdsourcing thing. So you had mentioned the 900 megahertz problem. Much of that isn't about the device operating. It's about it being chatty, about it not operating properly. It's proper in terms of some power mask. It's just not being nice. It's not being efficient. And some of that could be shamed into norms. And we see Wi-Fi that's inefficient in its use, that can cause, you know, you can change the network protocols, not the RF behavior necessarily, but how you're engaging that radio, and you can get much better sharing if you do a few things differently.
So,
And I'm just,
go ahead.
I'm going to throw an idea out that probably go over like a lead balloon, but what about the idea of a spectrum sharing database, or that shows areas where there's all kinds of spectrum available, even if it might be licensed spectrum, but there's nothing deployed in it, and that you could look at and say, you know what, there's nothing on 2300 megahertz, let's do something there. And then if something pops up, you can move it around. And I think that's something that's more possible with software-defined radios, because we've got billions and billions of Wi-Fi chipsets that are capable of operating through a pretty wide spectrum of frequency, that this would unlock just an incredible amount of spectrum that could potentially be made available. But it goes against our typical model of, I bought the spectrum, I own it, nobody else can do anything with it.
Well, part of the reason our model is I own this spectrum in gross is because of the legacy that if anyone else was using it, you would never trust that they could get off. And so to allow opportunistic use, which is the phrase that describes what Matt's talking about, you would need to have cognitive radios that could sense no one's using it. I think what's called policy engines, which would mean the radios could be told, okay, I can tell you in advance these things about this spectrum, and you need to follow these. And then maybe automatic shutoff so that people are confident that the radios would be responsive. Also maybe detections of people hacked their radio so it didn't do what it's supposed to do. You could, have a robust system enforcement. Those types of measures, as Matt says, are conceivable. My question, I want to get Ray here, is to oversee those measures, you need some type of, I'll call it trusted intermediary, which could be responsibility the FCC would all take on for itself, but history suggests the FCC is not keen to do that. It's tried to find other intermediaries, certifying bodies, other bodies. If we were to see a move in spectrum with some preset rules that would enable more efficient spectrum use but would require a trusted intermediary, Ray, what institutions do you see as sort of potential for the sort of model Matt's envisioning and Doug was talking about?
Well, when Matt was talking about the problems that he had, I immediately went and scratched on your paper. The analogy I thought of is what we've done in the electricity markets is come up with regional transmission organizations throughout most of the country, not this part of the country. But what the regional transmission organization does is it sits underneath FERC. It's a FERC-chartered nonprofit corporation that has the role of coordinating a number of things with regard to power supply in a given region. So it has power auctions, it monitors transmission congestion and transmission use, and it...
does it have some enforcement authority?
It does have enforcement authority to monitor market power problems that emerge particularly in specific pockets. And as Matt was describing the trusted intermediary that was, and RTOs have their problems, don't get me wrong, but they seem to function passably well in not adjudicating, but in enforcing norms in the electric markets that make those markets possible to work and to a degree thrive. Since all I can do is reason by analogy, since I don't really know that much about spectrum, the RTO notion was very resonant. It is meant to solve a lot of the problems that Matt was pointing to practically.
So I want to get the audience involved. As Pierre said at the outset, we've got some phenomenal people in this room. Our tradition in Silicon Flatirons is to start with some students. I have a number in my telecom law class, so I'm not afraid to call on. I think, Aisha, you have the mic there. So who wants to take the first one? Chris.
Excuse me. My name is Chris Laughlin. I'm at 2L. My question is mostly for Travis. It's kind of a two-part question. You talked about using ALJs as one tool among many tools. Can you give specific examples of when an ALJ has been used recently for spectrum adjudications? And if there aren't many examples, why is that tool not used more, particularly in consideration of the limited resources of the Enforcement Bureau?
Yeah, that's a very good question. We do have one ALJ at the FCC who works full-time on all kinds of issues, not just spectrum issues. And so there are, a number of ways you can end up before the ALJ. One way is the Enforcement Bureau could designate a potential enforcement action for a hearing before the ALJ. And that could be any potential enforcement action we wanted to do. Another is someone who is not being approved for a license, say for character issues, might decide when it's not approved, they might want to challenge it. And so they can force an action into the ALJ. I can't think of an instance offhand where there has been a resolution by the ALJ of a spectrum enforcement issue. I would go back to those 5 factors that I outlined earlier and suggest that, in the that the ALJ it's litigation. It's a long process. Most times when you have interference in spectrum issues, no one wants to wait 2 years or 3 years for that process. No one wants to get on a plane, or both parties don't want to get on a plane and fly down to Washington, D.C. to spend a lot of money to ultimately end up before the ALJ to look at this issue. So I actually think, and then frankly, sometimes it's not always clear who's causing the interference. I really want to emphasize that it's not as easy as a traffic ticket because you were driving above 65 miles per hour in a 65 mile per hour speed zone. And all the cop has to do is just look and say, aha, you broke the law. It's really not that easy these days. And I can't overemphasize how complex from a technological standpoint they could be, but also how many times when these issues can't be resolved by the rulemaking bodies or the rulemaking bureaus, they leave them ambiguous. They intentionally leave an unclear answer, and then it falls on the Enforcement Bureau to fill it in, or an ALJ to fill it in, to make these large-scale policy choices. I'm not sure that that's always the best way to advance spectrum enforcement policy, is when all the entities that have the most expertise, the most experience, that are really working on it, leave something blank, and then on a case-by-case basis fill it in.
Great question. Do we have another student question? Yep, Jolie.
So this is, I think, for Travis, but also others of you who've mentioned not not forgetting to let private resolution happen first, if possible, to maybe resolve disputes about interference more efficiently and also to save resources in the long run. But my question is, what would happen if that sort of private resolution among many different parties leads to different results in similar situations, but in different places or in slightly, different issues? And then when there is a higher level decision made by the Enforcement Bureau or through adjudication, or if the FCC gets around to defining really specific harms claim thresholds, what do we do to not either upset that balance that's been agreed upon by individual parties? And then also part 2 is, how do you exercise discretion in the Enforcement Bureau about which claims to fully pursue and adjudicate or resolve at the Enforcement Bureau, and which claims to encourage private resolution for?
Yeah, I'll start with your second one, then go to the first one. We try to anytime there's a private complaint, we try to encourage private resolution anytime. We automatically try to do that, because that is the most efficient use of our resources, is to try and get the private parties to resolve it. And the vast majority of the time, it works. I'll even go so far as to say much of the industry knows that that's going to be our first reaction, and so they've already tried to go down that road. That, to me, gives us a force multiplier effect, because we cannot, there are too many disputes out there for the government to resolve on any particular issue. You choose your issue, there are too many disputes for the government to resolve. This kind of moves into your second question, which is, how do you ensure some harmonization between the negotiated resolutions between private parties and the ultimate resolution that the government may reach, and what do you do when there's conflicts? Well, that is a scenario that comes up in any negotiated resolution. It has nothing to do with being unique to spectrum issues. The answer is, you hope that when parties negotiate a resolution, that they're both happy, that at the end of the day, they both walk away satisfied that they've reached the appropriate conclusion. Now, let's suppose the rules change, right? That shifts the bargaining position of one party vis-a-vis the other. And sure, they may have negotiated something, but now that the rules of the game are different, they might want to go back to the table and renegotiate. There's nothing that stops them from renegotiating a resolution in light of subsequent changes there, and we would certainly encourage it. I don't know if others have thoughts on it, but for me, I think in a world where So many of us are using so many devices that rely upon spectrum. It's impossible to envision any one government agency and resolving every single one of those in a timely fashion.
So Travis, let me ask, if Dale and I have a spectrum property dispute, and we're far-sighted enough to know that the FCC is going to mess with property rights sometime in the distant future, and we write into our agreement that when the FCC changes this, we still are honoring this agreement. Do you think the FCC in those circumstances would honor our agreement?
Good question. It's an excellent question. I think it depends upon what kind of change we're talking about. If the FCC or Congress passes a law, for example, that says you cannot do it, well, it's now the law, and you can't negotiate yourself out of a prohibition by either the FCC or by Congress. There are others, though, where they could be waivable, right? If someone sacrifices a right that they had as part of this negotiation, you could see that being permissible, just like I could make an agreement with Matt for him to engage in any number of activities that would potentially violate the law, to punch me without any problem, and there's nothing that anyone could do to move further than that. So I think that the short answer is there is no 100% say on how you'd resolve that, but if I knew the facts a little bit more, I could figure out, is that a waivable one or not?
So one of the interesting challenges here is how to develop transparency into the different sets of institutional arrangements that settle disputes. So what you'll hear about from, say, Verizon, Charla is here, is that they have figured this thing out, and so that with all the repeat players in their bands of spectrum, they've got a range of ways to accommodate, enforce, and resolve any possible differences, dispute issues. Where it gets challenging is where you've got different flavors of providers in different areas who don't necessarily have access to the same know-how, best practice. And so one role that the FCC can play, which happens in enforcement, is disseminating best practice among the different types of institutional arrangements that are happening. And that's an interesting type of role for an intermediary to play here. And that's one reason why being more high profile about settlements of, let's say, bad behavior, the Marriott case, is a really healthy function for the FCC, because the bad actors in the spectrum world, we have to collectively get them to stop acting that way. And there are different kinds of bad actors. So there's the Marriott case, but there's also the FAA case, which is like, I don't want to adopt new equipment. I don't want to use new spectrum models. I just want to keep the spectrum I have and use it inefficiently. That's not good spectrum acting. And how do we put pressure on people to raise their game and use spectrum more efficiently? Enforcement can be part of that equation as well. We had another question over here. You got it, Ralph?
Yeah, Ralph Brown, Cable Labs. One of the things I haven't heard discussed today is LTE unlicensed, the use of LTE protocols in the unlicensed band. And I wanted to pose a hypothetical and get a sense from the panel of how they might approach adjudicating or enforcement in this. If you had a wireless carrier who made extensive use of LTE in the unlicensed band to the detriment of Wi-Fi in that spectrum, what would that determination, or what would be the adjudication that you could approach?
So just so everyone has a level set, Wi-Fi, the unlicensed bands have tended to have a Wild West live and let live. The only restriction is your power. As a practical matter, as Doug and Dale can explain, certain uses of spectrum will coexist better. And so Wi-Fi with Wi-Fi, there's lots of ways they can coexist. When you introduce LTE and Wi-Fi together, you raise all sorts of complexities. So as both a legal and a practical matter, how would this issue get handled? I think the legal answer is there is no rights of unlicensed users to stop other unlicensed users. And this literally, Ralph, gets to this conference in March, which talks about governing the commons. And the tragedy of the commons is if people all act unreasonably, if there's no legal regime that stops them, then you have a tragedy of the commons. And I guess there are practical answers about how people's behavior, and Matt, this goes back to our discussion earlier, what type of practical constraints are there for people, let's say, acting in ways that are going to have the pretty foreseeable effect of making life harder for everybody. And introducing LTE into Wi-Fi in the same bands, I take it, would be one of those things.
My understanding of LTE is it's not very interference tolerant. So the problem would take care of itself pretty rapidly in that you wouldn't be able to assure the same kind of resistance to, or you couldn't handle the same kind of degradation of performance that Wi-Fi has, a little bit more graceful degradation than LTE, from what I understand. So
put differently, if you wanted LTE and unlicensed, you would need the FCC to specify that anything that that would harm LTE is not allowed, because otherwise LTE is going to get crowded out automatically.
Yeah, it would be impractical to try and deploy it there.
So before Ralph gives a retort, Doug, is that consistent with your?
No, it's not. So there's a lot of work being done right now on this issue, and the different forums are coming together, trying to figure out if there's etiquettes that could be applied. It has a lot of people in the unlicensed community very, very uncomfortable, as you can well imagine, this idea. And it's not as simple as 802.11 is going to step on or be able to work around LTE, and LTE would degrade more poorly. Actually, it gets to the issue, and I've seen some studies on this, where ultimately it really messes up the spectrum. So I don't know how we're going to move ahead. I know that different groups, including, I'm sure Ralph has something to say about this, there's people who are trying to figure out what's an appropriate etiquette, how would you actually share this, and 3GPP has done some in this space. I'd love to hear what you have to say, Ralph.
Dale wants to jump in before we go back to Ralph.
No, I could do it later, but I would like to comment.
Yeah, no, Dale, you give your comment. You go first, then Ralph.
Well, I mean, to me,
Our etiquette is
once you get down the road of the government deciding what's compatible within the unlicensed band, now we're right back to comparative hearings, we're right back to long processes again, and that's not what unlicensed was all about. And I just wish the industry does get together and try to figure this out. But that's where we're heading, because I'm going to do a point-to-point video link that's going to be on the air all the time. Now, I don't share very well with somebody who's using a contention, right? So are we going to ban? We're going to ban the use of point-to-point video links in unlicensed? I just don't know where. I don't know where it stops. And we've got something here that's really worked well. So I'm scared to death that it takes us right back to having the government making decisions.
So the government, for the record, in some unlicensed bands has had some mandated etiquette. So the listen before talk is a famous one. And it's kind of like a commons, where you have certain rules of how you use the commons. Again, we're previewing the March conference, so I hope we're getting people's appetites going. Ralph, you want to?
Are you talking about equivalent power levels? Even if that is the case, how much of mobile device traffic is running on Wi-Fi right now? That's where I see if LTE can come in and disrupt existing Wi-Fi traffic, which is somewhere between 60 and 80% of the traffic going to mobile devices. There's kind of a...
Well, this is an apples to oranges point, though, because right now the current Wi-Fi has got to be on a different band than the LTE.
Right.
Right? If you put them on the same band, I think that's where Ralph's concerned. But so I think one thing that I'll say, and then we got to keep this for the March conference, is there's a real challenge in Spectrum and in Commons where the first user has certain reliance interests. And so, Dale, depending on what the facts are, it could be the Wi-Fi users saying, don't let LTE in this, because you'll then overwhelm our legacy use. Right? And that would be a potential challenge down the road. So Paul wanted to go, I think, back on another topic, and then we'll go to the other side. So Paul?
Yeah, so I have a question for Travis. I appreciate the remarks, they're really helpful. One of the things you talked about was having the kind of cop on the beat go and try to resolve interference disputes quickly, and I think that's an appreciated thing. But it's really difficult when the rule that you've got says interference is not illegal, harmful interference is illegal. So when your guy goes and knocks on the door, how do you tell him what the difference is between those two things? And how does he know I'm not shutting down interference, which might be efficient, versus harmful interference, which is against the rules, on a case-by-case basis in the field?
Sure. It's not always easy. I've been using the term interference, but generally I am referring to harmful interference. When I use the term interference, I'm not just talking about an amorphous concept of interference. We do research beforehand, not just legal research, but also we use the tools that are available to us to figure out what's going on, to try to analyze the situation before we end up ever going to a door. And even once we get there, we still do further testing. So we have a lot of tools that are available there when we're trying to assess who's at fault. If we can't assess it, then we can't take an enforcement action. Or we have to think about another way to resolve the issue. But generally speaking, at the point with which, generally every time that we issue a citation, we are reaching the point where we've decided that there was actionable interference.
And so when you bring this technology to bear, what's the standard that you're telling the technology to look for, right? You can say, hey, I see energy, but at what level do you say, now this is actually crosses that threshold, right? You can see it, you can have great technology, but unless you know what to tell the technology to look for, you might be taking out interference that's perfectly fine as opposed to harmful interference.
Yeah, you're kind of out there trying to figure out what the situation is. I would suggest that maybe we can have a long conversation about that. You're actually sitting right next to Rebecca Dortch, who is sort of the head of our Western region for our field offices, and they do this on a daily basis of going and dealing with these issues, and how we get there, how we decide, how we do it. It is not a simple answer.
Well, I think one point to answer Paul's question is you will have occasional extreme cases, the easy cases. I think Paul's question is very interesting when you get to the harder cases, and it's quite possible that those end up having to get referred for some more process. And then the question you beg is, how do you decide where the easy cases end and the hard cases begin? But there are cases where someone would clearly be operating in a band where they don't have a license, and they're creating interference with someone who does. All right, let's go around to the other side now, and let's go to Dan.
So I just wanted to sort of push it in the direction of a future-looking enforcement bureau. Just to give you a chance to talk for a minute, Travis. What does your group, that 1/3 of those people that are focused on spectrum, look at as a resource multiplier for you? And I say that in the context of the SAS and the coming of the 3.5 gigahertz solutions that are going to be in the marketplace. Do you see anything that you want to talk about today that's forward-looking that is going to augment your resources?
Yeah, I think we have to look at how we can transform our spectrum enforcement into operations that can handle the problems of the 21st century and the spectrum enforcement issues that we see today. So we have to think about force multipliers, right? So right now, a lot of times when we do our sort of our spectrum enforcement, we have to send someone out. We have to send 2 individuals out, and they have to be there on the ground to actually figure out what's ongoing, and they have to be there when the interference takes place. Imagine if we could deploy something that we might be able to leave stationary, that'll actually do the monitoring for us, the detection for us, so that we don't have to have 2 people there the entire time. So those same 2 people can now go work 5 different cases all at once, right? That's a force multiplier effect for us. Secondly, I think we have to think about how we can make sure that even when we are engaging in, standard work we are possibly looking for other issues as well. Maybe we're surveying what's ongoing around us so that we can go back and analyze it later on to see if there were potential problems there. I think we can try and spot problems up front rather than waiting on someone to call in and complain about something. Let's say a new band or new service is rolling out. Imagine if we were already there looking for interference there before it ever even started so that we could raise issues to prevent it, so that we were not responding to as many complaints because we've handled it on the front end. Fundamentally, we have to modernize our efforts at enforcement so that we have the technological expertise as well to actually to engage in interference detection at some of the higher bands, in particular above 3.5. We need to make sure we have the right tools that are available for us to do it there. So we need to make sure our technology is there. We need to make sure our training is there for the folks that we have doing spectrum enforcement. We need to make sure that we have deployable technologies that don't require two human beings to be there as well. And I think that'll help us to better perform our mission in the future.
Well, one question, Travis, on this is getting to raise trust intermediary. I could imagine some, trusted body who had the type of situational awareness you're talking about, like the credit card companies have for fraud detection, which notices something different's happening now and then gives you guys a tip. It's not a priori clear whether or not that needs to be in the FCC or in some adjunct body like the RTOs are to the FERC.
Yeah, I don't want to make a policy judgment on it. I will say that having other entities which are monitoring spectrum, which are reporting issues to us, makes our jobs easier, allows us to be more efficient, and allows us to determine what's the best use of our resources, our enforcement resources. So it's a great value to us.
Could I?
Yeah, please, Dale.
Well, I just say that one of the TAC recommendations was there's an awful lot of people out there collecting information on signals today, and it's generally in stovepipes. And one of the proposals was, could there be steps taken for more sharing? You need to sanitize things, but more sharing about different people gathering information. And the intriguing part of that, it ties back to your comment too. If you're getting those reports from lots of different sources back, and you see the rise of a particular electronic ballast or something like that's where you're seeing your interferences, then you could begin and get in front of it. So I think you don't have to go all the way to crowdsourced. You can just share, I think, some of the existing spectrum that's monitoring that's being done today.
And can I add just one last thing to that quickly, which is that intelligence gathering that Dale's talking about would be of great value, particularly when you could combine it ultimately with data analytics. Right? Imagine when we can start to use automated mechanisms to engage in spectrum analysis and help us with our enforcement. And I think those tools are becoming available to us, and we really need to look at how we can employ those into our spectrum enforcement work.
Can I add one really short to pick Dan's? The other thing is today we make a standard spectrum analyzer. You're not collecting the I and Q information. Today it's possible to collect it, which means that you can do forensic analysis. In other words, you can go back and look at a band and say, I didn't see this particular bad signal in here today when I was just casually, but now I'll go back and use processing to dig out and find that signal in there that shouldn't be there. So to answer Dan's question, that's the sort of technology I think we can begin to...
It fits with Matt's objective, which is more opportunities to use the spectrum, which is, okay, what bands aren't being used at all right now? It's the same technology to keep an eye on that versus what's being used in a funny way right now. Getting that information collected, because as Dale says, a lot of it's out there, and then analyzed, will make the FCC more effective. Let's give Rich the last.
Just one quick thing.
Sure.
With aeronautical measurements, the devices now to do this sort of thing are getting so small you can carry them on light aircraft and so forth. So to help you, rather than having to put a lot of cars out trying to measure stuff, you can do flights now that collect a lot of that information that would tell you where people are and aren't. Yeah.
Coming to a neighborhood near you. All right, Rich, you get the last question.
Okay, there's well known to this group, a new policy on the shelf called harm claim threshold. So I had a question, I guess, for Travis, and hopefully Dale and Doug can chime in. But if we can move to harm claim threshold, there's a lot of benefits. Receivers can get expected protection in that regime. We're going to have a lot more monitoring. That's the friend of force multiplication. But has the harm claim threshold been looked at operationally through your group so as to, build an enforcement capability to support it?
So Travis can't give away any secrets here, but I think the question is, to the extent the FCC is looking at testing harm claim threshold, is the Enforcement Bureau on the front end being brought into those conversations?
One of the things I've been trying to do with the Enforcement Bureau under my tenure has been to get the Enforcement Bureau at the table with the rulemaking bureaus as they're looking at policy options, as they're thinking about writing rules, so that we can, number one, assist them with writing rules that are enforceable. Number two, we can understand their priorities so that we're enforcing around their priorities. And number three, so that we can provide them with feedback about what we're seeing on the ground when we're out actually doing our enforcement. So we're trying to engage with them. Obviously, I can't comment on anything that the FCC may or may not be doing right now. I don't know if Dale wants to.
You're good at giving that answer, Travis. That was really well done.
Maybe, I think is what he said.
It was actually, I'm trying to pretend I'm answering the question, but really I can't say anything about that, I think was what he was saying. I want to thank this panel for a really great discussion. It's been really interesting and valuable, and we'll take a very, very short interlude to bring up Mr. Raymond and Commissioner Clyburn. Thank you very much, everybody.